Hello, everybody.
Oseki, I know that you know this process, but we do have to go through it each time under the People versus Anderson Michigan Supreme Court case. You understand that you've asked to represent yourself.
Yes.
You still want to represent yourself.
Yes.
You still understand the maximum penalties you're facing if convicted.
Yes.
And you understand that if you made a request to have a court-appointed attorney assist you, I would appoint an attorney to assist you. You understand?
I understand.
And you still want to represent yourself?
Correct.
Do you have any questions about any of that?
I don't think so.
If you think of any questions during the proceeding today, make sure and get my attention so that I can answer them. You can ask for one and I'll provide one for your assistance.
I would like to say something about, I got a 7-day notice about a decision. And it was your record for law.
I don't know what 7-day decision you're referencing, so what one are you referencing?
Well, I had a hearing on March 5th and I got a notice and it said that you made a decision on January 29th.
So what happens, and perhaps this will answer the question, and perhaps it won't, but whenever we have hearings, I require a party to file an order. And when the parties don't consent to an order, so if you both consented to it, I could sign it, then it's submitted under what's called a 7-day rule. And I sign 7-day orders all of the time because what happens is if the prosecutor, for example, submitted an order, you have 7 days to object to that order. If you objected to it in a timely manner, then we'd have a hearing regarding it. But if you don't, the court's presumption is the order was accurate because otherwise there would have been an objection. So was there a 7-day order? Let me just check the court file and see if I can identify the one you're talking about. Are you talking about an order following the hearing?
It was March 10th and it said it was for the decision on the 29th of January.
All right, and so I'm seeing that order. It looks like I signed it on March 20th. Again, I signed a 7-day order when nobody's objected to it after 7 days after the prosecutor or whatever other party files it. So I signed it. It says that the matter has come before the court having reviewed the files and records herein, having heard the arguments of counsel and being fully advised on the premises hereby orders that the defendant's motion to dismiss dated January 29th, 2025 is denied for the reasons stated on.
Well, that's not true though.
Well, what's not true about it?
It wasn't denied on the 29th of January.
Well,
It
whatever
was
day,
denied on the March 5th.
whatever day it was denied, it was denied. The order says that your motion that was dated.
So it doesn't have to be accurate then?
It's accurate. Your motion was dated January 29th. I denied it in the March hearing.
Oh, okay.
Your
I
motion
see
was
what you're
dated-
saying. Yes, I
Your motion
understand.
was dated January 29th.
I completely understand.
Okay, so it is accurate, yes.
Okay.
Yes.
Uh,
Well,
If you say so.
you filed the motion, you're the one challenging it, Mr. Massey.
But I didn't file the motion on the 29th.
Well, here's the way I view it. You're the one complaining that there's an error and that established to me that there's an error. So I'm not going to take any further action on that issue, but I do want to move on to the next issue, which is the motion to adjourn trial. Did you get a chance to see the prosecutor's motion?
Okay.
Did you get a chance to see the prosecutor's motion?
The motion for June 12th.
The motion to adjourn the trial, the one that we're here for today.
I'm not sure of that. No, I don't think I did.
Mr. Ziegler, do you have a copy of your motion to adjourn trial that you can hand to Mr. Lasecki? Sure. I'm looking at the court file and the proof of service. This motion to adjourn trial was filed with the Kalkaska County Clerk on March 28th. The proof of service hand signed by apparently Mr. Ziegler indicates that there was a copy provided to you at US mail. So take a moment to review that motion and then tell me if you've had a chance to see it yet. It's the same motion that the prosecutor brought up orally at the conclusion of our last hearing, and I told you you had the right to object to it and file a written response if you wanted, or I'd address it whenever the matter came up again before.
I've never seen this motion.
What's your mailing address? And is that the address that you have, Mr. Ziegler?
That's the address we mailed to, Your Honor. Yes.
Alright,
May have other filings there before in the past.
Right. So, Mr. Lasecki, did you have a response to the prosecutor's motion to adjourn the trial?
My response to that is, this has been going on for like a year and I would like to get it done.
So would I. But one of the ways that we need to have it done is we need to have all of the necessary witnesses present. And so I'm going to go through it this way, and I'll let you have the last word. Mr. Ziegler, if you had argument, I'd allow it. I think I fairly easily understand your motion and why you're filing it. But did you have additional oral argument wanted to offer in support of your motion?
Your Honor, just to the terms of the delay, I know this case has been proceeding for some time, but most of that delay was not the people's request. In fact, we had a trial set. I want to say it was maybe in January, and it was adjourned at the defense request so he could file some motions. He's filed those motions. They've been denied. The requested adjournment is only for 30 days time. Your clerk provided me a date of June 12th, which Mr. Lisecki seemed to be aware of. So for that reason, Your Honor, I don't think it's a meaningful burden one way or the other to adjourn trial for 30 days to ensure that the officer can attend his training and is available for trial.
Did you have further argument you want me to consider, Mr. Lisecki?
That is not accurate. It's been for trial in November. It's been changed to February. It's been changed, multiple times.
Mr. Lisecki, the court needs to make a finding of good cause to adjourn any trial. And in this case, the purported or claimed good cause by the people is that trial was set. He was made aware of the date. He brought up to you the fact that he had an officer that was set for a training on that date. And that training is for basic firearms instruction, where the Kalkaska County Sheriff's Department has arranged for payment for that, and it costs the county $300 for this officer to attend the training. If I continue the trial on May 12th, that would prevent Mr. McCormick, Officer McCormick, from receiving the training, which would generally have a negative impact on the proper Kalkaska County Sheriff's Department, as well as in Kalkaska County in total. And the request is simply to adjourn for a month so that he can both attend the training and that we can have a trial. That does not appear to be an unreasonable request. It's also not unreasonable for you to want to have trial, but it is accurate background that we've had this trial set multiple times at least. And at least on one of those occasions, you requested an adjournment because you wanted another opportunity to file a motion, which I let you do. It wasn't unreasonable for you to ask for an adjournment for that purpose. It's not unreasonable for the prosecutor to make a request to adjourn trial here. And more specifically, you haven't told me that there's any prejudice to you. I understand what you would probably say if I let you speak again, is that the prejudice comes just simply in the delay. You want to have this matter off of your chest and out of your mind, and I get that. I also want to get this matter resolved. But the way that I can do that best in using my time is to make sure that everyone that's necessary for trial is there. Here's the downside, is if I found some compelling argument by you, that compelling, and I decided to keep trial on, the prosecutor could, if he decided to, simply dismiss the charges and refile later. That would be a way that has nothing to do with this court's exercise of discretion, which would serve to delay your case further. So what I'm bringing up to you is that probably what you're not seeing is that even if I denied the prosecutor's request, there are potential other ways that the prosecutor could still adjourn the trial without asking me for permission to do so. I don't think that makes much sense, and I'm not suggesting I think Mr. Ziegler would necessarily do that, but it's something that would definitely affect you. It would create more prejudice because it would create more delay. So I don't find that there's any prejudice to the delay. The delay is relatively short.
I have never adjourned.
Well, I'm not really going to have a back and forth argument with you, Mr. Lisecki.
I'm not arguing.
Well, that's exactly what you're doing. When you disagree in a defiant manner in the courtroom with something that I've said, that's the definition of an argument.
True.
So we're going to disagree and we'll be fine with that, both of us. The order is that I'm going to grant the prosecutor's motion to adjourn trial.
Your light's still red, just so you know.
The red is good. The red means we're recording.
Okay, I heard green.
The red is good.
Okay, thank you.
So we're going to have the new trial date set. And I think in your proposed order, Mr. Ziegler, you had already had that new date, did you not?
I did, Your Honor.
And so I want to make sure
It's in the order.
it is in the order part. And so I'm just going to simply sign this order. Do you want me to use the separate copy, not the one that's already in the court file? There's a proposed order in the court file.
Yes, there's a separate copy.
I think I have a separate copy of the order.
Can you tell me the date that I adjourned?
No, I'm not going to go through any more of the dates. They are what they are, and you
Thanks
have
for your help.
you have the ability, Mr. Lisecki. This is not a complicated process. You've been in court during all of the proceedings, and every decision I've made, you've been looking right at me when I made them. So
Okay.
to the extent that the dates were not January 29th or not March 5th, the dates are irrelevant.
Well, they were
The
March
purpose of the dates is that we were all together talking about the case. we're not going to consider covering what I view to be old ground. And this is a situation where Mr. Lasecki, again, as I told you most times, because I have to make the finding, I've generally found you to be communicative and cooperative and not difficult. That's the reason why you're still representing yourself in part. Part of it is because you've asked for that. But that right to represent yourself is also limited to the extent the court finds that you're being problematic or making it difficult for me to do what I view as fairly simple things. I'm not in a position to or want to make a change in how you're representing yourself. But if, for example, during your trial, you are so difficult that I have to rehash old things and I have to have conversations over and over again, it may make me decide in my discretion that you're not able to do the role of representing yourself sufficiently, and that you're going to cause difficulties for the court. And I'm just reminding you that if you make me make that decision, that allows the court to then force counsel upon you. I'm not telling you I want to do that. I'm telling you I don't. I want you to be able to represent yourself. But if I have to get in back and forth verbal spars with you, especially if it's in the presence of a jury, it is not going to be to your benefit. I don't allow that to happen from attorneys. I'm not going to allow it to happen from litigants, including you, even if you're representing yourself. So I'm putting you on notice. If you make me do that, particularly in the presence of a jury at a jury trial, it's going to have negative consequences to you in that you're not going to continue to be able to represent yourself. Do you have any questions about what I've said or anything I can further explain for your benefit? Is that a no? Mr. Lasecki, this is the type of behavior that's going to land you in proverbial hot water.
What do you mean? What am I doing?
You know exactly what you're doing, but I'll explain it to you very clearly and cleanly on the record so that you know further. When I ask a question of a prosecutor or a defense attorney or a witness, the required response in a courtroom is a verbal response. And it's verbal for the benefit of you, the benefit of the prosecutor, and my benefit. It records everything. That's why these lights are on. We record every part of a court proceeding so that everyone, including the Court of Appeals or the Michigan Supreme Court, has access to it later. Therefore, if I ask you a question and you don't verbally respond, it's going to, as you can see how it's affecting me right now, it's going to make me upset because it's a clear and easy process. Verbal responses are able to be transcribed.
Sir, I don't want you to get upset.
I don't want me to get upset either. And it's not a particularly difficult conversation we're having, except the way that we have to have it. Do you have any other questions that I can answer for you so that you can understand why I get upset over simple procedural issues?
No, sir.
Mr. Ziegler, do you have anything further you think the court should cover today in advance of our impending trial date?
No, Your Honor.
Mr. Lasecki, I'm going to see you at the morning of trial. That trial date has now changed, of course, but the requirement is, again, that you're here, present, ready to go no later than 8:30. Do you have any questions? Most times I've broken after these hearings by offering you the ability to question the court about general procedural matters at trial. Do you have any general questions about procedural matters at trial, what happens when it happens, or so forth?
I do not.
All right, we will see you at your trial date then. Do you need to get a copy of that trial date now, or can we mail it to you?
I should probably get it now because I didn't get a copy of this, but I did get a copy of the notice of judgment.
Can you get a copy of that order for Mr. Lasecki right now? Sure. So Mr. Lasecki, just stick around for a little bit.
Okay.
We'll have the clerk provide a copy, but I just signed it today. It has a new trial date on it. Again, 8:30 more in the morning is a requirement for you and the prosecutor to be here.
And I should be here a half hour early.
Right, half hour before
Okay.
the start of trial, which is 9 o'clock, so no later than 8:30 in the morning.
Okay.
Yes, sir. All right, thank you. The court is in recess on this case.
God bless you, sir.
As well.
All right, guys. Be safe, be well, sleep sweet, and much love.